posted public hearing this evening is 26, 28, 24, 26, 28, 30, Second Lane, Hart Pond Development LLC for an administrative appeal to the Chelmsford Zoning Board of Appeals. The applicant seeks to appeal the May 4th, 2021 building inspector's letter of determination stating you cannot have multiple principal structures on one lot. And if the applicant would like to open it up, I think that would be a good idea.
Thank you, Mr. Chairman. Ryan McManus of Hemingway and Barnes on behalf of the applicant here, the owners of this property. The owners are both with me here today. They're Patrick Larkin and Michael Larkin. As you noted, Mr. Chairman, the procedural posture in which we're before this board is an appeal from a denial of building permits for this project. So we're not here seeking a special permit or a Section 6 discretionary finding. The position of the applicant is that it is entitled to build these structures as of right under the zoning bylaw and under Section 6, the statute, and that the building commissioner erred in denying the building permits. The building commissioner denied the permits on the grounds that the new structures that were proposed were not within the same footprint as the existing structures, and we think that that conclusion was incorrect. And just by way of context here, I know the board obviously is familiar with this project, and we've been before the board before, but the project here consists of the reconstruction of 4 existing non-conforming structures. There are 4 non-conforming structures on a single lot on Second Lane down by Hart Pond, and the proposal is to remove those structures. They are quite old and in need of significant repair, and to reconstruct them with 4 new single-family homes. So there's 4 existing single-family homes, and the proposal is to reconstruct 4 new single-family homes. What I'd like to do to start is just try to find some common ground. There's a lot of issues that have been raised, and I'm hoping, perhaps with the help of town council, who I know submitted a letter this evening, we can find some common ground on certain issues that will focus our discussion on what I think are really the questions that are before the board right now. And so I want to start just by reminding the board that there is a important distinction between non-conforming structures and non-conforming uses, and we've heard issues raised with respect to both. But non-conforming structures and non-conforming uses are both regulated separately, and they need to be assessed separately by this board. And I'll start with the structural non-conformities. The 4 single-family homes on this lot are non-conforming structures, pre-existing non-conforming structures, because they pre-exist the adoption of the bylaw that makes them non-conforming. They're grandfathered structures, in other words. And the reason that they're non-conforming is they don't comply with certain setback requirements. I do want to address, there was a question raised, I think, at the last hearing by Mr. Chairman, and about one of the structures that is not entirely on this lot. It actually encroaches over into the other lot, which is the case. Another one is up against the lot line. But I just want to make clear, so there's no doubt, the applicant owns all 4 structures, and therefore, for purposes of their grandfathered status, all 4 are entitled to the same protection under Chapter 48, Section 6, and under the bylaw. The bylaw, which I've included at the relevant portion in the slides that I handed out. Unfortunately, I don't know. Colleen, were you able to pull up that slide deck that I sent, or is this?
This is the application.
Oh, okay. I don't think we have the electronic slide deck, but I did hand out some hard copies, and I've included the current bylaw. And as everyone knows, this is a relatively new bylaw, and it was revised recently. And I want to point out in particular, one of the ways that it was revised, the old bylaw said that you could reconstruct non-conforming structures, but that the size of the new structures was limited. Depending on the size of the lot, there was a sliding scale, and it went up to 30%. So as of right, you could reconstruct a new structure that was up to 30% larger. That size restriction was eliminated in the new bylaw. There is no size limitation on reconstruction, but what there is setback requirements. If you comply with those setback requirements, then for the purposes of structural nonconformity, and I'm going to talk about use in a minute, but focusing on the structural nonconformity, what the bylaw says is if you comply with these setbacks, you can rebuild as a matter of right. This project does comply with those setbacks. I don't think that that's in dispute. Happy to answer any questions about that if there are any. But it does comply with those historic setback requirements. And therefore, again, it's our position from the standpoint of structural nonconformity. This is permissible as of right under the bylaw. I understand that Town Council has submitted a letter this afternoon to the board. I've read that as well. My understanding is that Town Council comes to the same conclusion with respect to the structural nonconformity, that reconstructing these buildings as proposed is permissible as of right from a structural standpoint. But I guess I want to maybe stop and pause there because, as I said, my hope is that we can find some common ground and focus on what issues I think are really critical for the board to address. So are there questions on the structural nonconformity piece of this? Because I realize the building commissioner did come to a different conclusion than Town Council did, but I know we have Town Council here tonight, so I'm hopeful we can find common ground on that issue.
So I think I understand what you're saying. I think it's a little circular because we still have the same problems. I think what I'll do is read the lengthy letter that Mr. Haverty sent us and give you his point of view on it, which I have read and will read into the record now. Regarding 2430 Second Lane, dear Chairman Reedy, I am in receipt of a letter submitted by the board by the applicant's attorney dated June 3rd, 2021. I have also reviewed the video of the board's meeting on June 3rd, 2021. Please accept this correspondence as my response to the issues raised in the letter from council and from the board's June 3rd, 2021 meeting. I reviewed the language in section 195.8.1 of the Chelmsford zoning bylaws, which states that for single and two-family structures, under the circumstances set forth in subsections A through D, a reconstruction, extension, alteration, or change shall not be deemed to increase the non-conforming nature of said structure. Subsection A states that the reconstruction, extension, alteration, or change that conforms to the dimensional requirements at the time the structures were originally constructed shall not be an increase in the non-conforming nature of the structure. The provisions of the section of the Chelmsford zoning bylaw are more permissive than the protections offered to the pre-existing non-conforming single-family structures pursuant to General Law, Chapter 40A, subsection 6. Accordingly, it is my interpretation of this section of the bylaw that an allowed reconstruction, extension, alteration, or change of the existing structures at 2430 Second Lane that complies with the then existing front, side, and rear setbacks, and in fact, at the time of construction of these structures, respectively 20 feet, 10 feet, and 10 feet, will not constitute an increase in the non-conforming nature of the structures, thus does not require relief from the board. This presumes that no new nonconformities of other dimensional requirements, such as lot area or height, not mentioned in section 195.8-1, are created by the proposed work. So I think that you're both on the same page in that portion of this. The next question that arises is whether the voluntary demolition of a pre-existing non-conforming structure to be replaced by a new structure in a different location on the lot falls within the definition of the relocation of the bylaw. In my review of the relevant case law pursuant to General Law, Chapter 40A, subsection 6, I found the case which specifically states that the definition of reconstruction would allow reconstructing a structure at a different site. Note that it's a site, not on-site. See Gideon versus Zoning Board of Appeals of Nantucket, 82 Mass, Application Court, Appellate Court, 406, 2010. As noted it by the Land Court in the subsequent case, it seems clear that given the facts of the Gideon case, that when using the term site, the Glidden Court was speaking not of a different lot, but of a different location or site on the same lot. Gnomes versus Collins, Land Court, miscellaneous 446909 order, February 7th, 2013, J. Grossman. The appeals court subsequently overturned a land court decision finding that the term alteration did not encompass constructing a new structure in a different location that was 4 times as large as the original structure. Schiffenhaus versus Klein, 79, Mass Appellate Court, 600, 2011. The Schiffenhaus case determined that a finding from the board was required. However, this is an unusual circumstance as the proposal did not demolish the existing structure, but instead to remove kitchen facilities from the original structure, thus making it an accessory structure to the proposed single-family structure. After reviewing the relevant case law, it is my interpretation that a reconstruction of a single-family structure is allowed both pursuant to General Law, Chapter 40A, Subsection 6, and Section 195 of the Chelmsford zoning bylaws, even when such reconstruction is from a voluntary demolition of the structure. Although Section 195A of the zoning bylaws allows reconstruction of a single and two-family structures as of right without the requirement of finding from the board, there is alternative grounds for the board to uphold the determination of the building commissioner that the applicant was not eligible for an issuance of a building permit without a finding from the board. In addition to constituting pre-existing non-conforming structures, the structures located at the property collectively constitute a pre-existing non-conforming use. Specifically, the property contains multiple principal structures on a single lot, which is not allowed in use in Chelmsford residential zones in the town of Chelmsford. As set forth in Powers versus Building Inspector of Barnstable, 363 Mass 648-653, 1973, the test to determine whether non-conforming use will be substantially extended and requires a 3-part determination consisting of 1, whether the present use reflects the nature and use of the prevailing when the zoning bylaw took effect, 2, whether there is a difference in the quality or character as well as the degree of the present use, and 3, whether the current use is different in kind in its effect on the neighborhood. An affirmative answer on any of these 3 questions supports a determination that the non-conforming use is not protected. The applicant argues that the proposed reconstruction of the 4 single-family structures in the property will not constitute a substantial extension of the pre-existing non-conforming use of the 4 principal structures. However, none of the cases cited by the applicant address a situation where multiple principal residential structures on a single lot are proposed to be demolished and replaced with new structures containing significantly larger square footage. In the case of Oakham Sand and Gravel Corp. Versus the Town of Oakham, 54 Massachusetts Appellate Court, 8085, 2002, the appeals court upheld the decision of the land court, holding that an increase in sand and gravel production, along with a doubling of the land area used for sand and gravel removal, constituted an improper extension of the pre-existing non-conforming use. Here, the applicant proposes to greatly expand the floor area of the property and also increase the building coverage of the property. Additionally, the applicant's proposed increase in the size of the single-family structures is also likely result in an increase in traffic on the property, another potential factor in determining whether an extension of the pre-existing non-conforming use would occur. Ultimately, the board is only being asked to rule on the validity of the determination of the building commissioner that the proposed is allowed to obtain a building permit as of right. For the reasons discussed above, it is my opinion, one which the applicant has been aware of since last fall, that a building permit may not issue without a finding from the board that the proposed reconstruction does not constitute an extension of the pre-existing non-conforming use. Accordingly, the board should uphold the determination of the building commissioner that the applicant does not have the present right to a building permit. Yours truly, Paul J. Haverty, Esquire. So I think he's in agreement with you on the structure matter, and that's where we are at this point.
I think that's correct, Mr. Chairman, that as I understand Town Council's letter, he's in agreement that structurally, these are permissible as of right. He's in agreement that it need not be constructed or reconstructed in the same footprint. In other words, the structures can be relocated on the same lot. And that gets us, I think, to the question of use. And is there a change or substantial extension of use? And the powers test that was cited in here. There's one issue on which I think I disagree with the letter, and I'm not sure. I spoke with Town Council briefly this afternoon to just note my concern about one part of that, and that is the question of whether this is a change or substantial extension of use, in our view, is ripe and is before the board, and the board can decide that now. In other words, it's not proper to require the applicant to apply for a special permit on that issue. Whether there's a change or substantial extension of use is the threshold question that determines whether we need to seek a special permit. So in other words, if there's been no change or substantial extension of the use, this is permissible as of right. If there has been a change or substantial extension of the use, then we do need to apply for a special permit and get that special finding from the board. So on that point, I spoke with Town Council. In our view, a change or substantial extension, that's really the question that this board needs to decide. If the board concludes that this would be a change or substantial extension, it can affirm. If the board concludes this would not be a change of use or a substantial extension of use, then in our view, it cannot affirm the building commissioner. Because if there hasn't been a change of use or substantial extension, this is allowable as of right. So we think that question is properly before the board. I don't want to speak for Attorney Haverty. I think he and I came to some understanding on that in the call today, but I know he's here and he can speak to that himself.
I will ask Paul if he has any input to the matter other than the letter that was so longfully written.
Certainly, Mr. Chairman. Again, for the record, Paul Haverty, Town Council. I do agree with Attorney McManus that the board can and should make the determination as to whether or not there is a substantial extension tonight, because if there is a substantial extension, then the decision of the building commissioner should be upheld. And if the board determines that the change is not a substantial extension of the pre-existing non-conforming use, then the determination from the building commissioner should be upheld. So I do think that the board needs to make that determination. I did lay out in my letter the factors that the board needs to consider in making that determination. There really isn't much help in the case law as it applies to an extension of a use that is essentially multiple principal structures on a single residential lot. So a lot of the examples certainly that were cited by the applicant, really have to do with commercial uses, have to do with degrees of increase in the use that are going to have different impacts in a commercial zone than what the impacts are going to be on the degree of an increase in residential use in a residential zone. So I do think that you're dealing with a different type of a threshold. There really isn't much guidance in the case law that you're going to be able to look at, and I think you just need to make your best determination based upon the factors that are set forth in the powers decision.
Very good. Thank you. I think at this time, I'm going to sort of instruct everyone out there. I will make time for anyone to speak. I think it should be reasonable. We don't want to repeat a lot. But what we're deciding tonight is whether the proposal is a substantial change in use from what exists. Whether there is some horse trading as to whether there's more or less or anything like that is not on the table at this point. We are simply here to determine whether the building inspector letter will be upheld or denied. If it is denied, then the applicant would be able to build by right. If it is upheld, then the applicant would have to go through another process to get the right to build. So as far as understanding that, I know there's a lot of people very passionate about what they believe, what should go there, what shouldn't. we're not making any of those decisions. We're just gonna decide whether, by what we have in front of us and the law, whether he is allowed to do the units or not. So I'll open it up to the public. Please approach the podium, your name and address, and anything you want to say, but try to avoid repeating if you can. And keep in mind that we're not going to adjust anything from the application. That's not happening at all. It's not any kind of negotiation with that. It's just whether the application as it sits is by right or not.
And Mr. Chairman, if I may, and I know there are probably a lot of people who want to speak, I do want to address the question, which I think is the correct question for this board: is this a change or substantial extension? And I'm happy to do that now. I'm happy to do that later, however you prefer to proceed.
You could speak to it at this point, I think.
Thank you. And again, I'll try to be as brief as possible. I have addressed this to some extent in the slides that are in front of you, beginning on page 15. The first 14 pages or so are devoted to the structural question, and the use question is addressed page 15, 16, 17, and 18 primarily. First, I want to say, with respect to change in use, this is not a change in use. This is single-family use to single-family use. 4 single-family structures to 4 new single-family structures. A change in use would be single-family residential to commercial, commercial to industrial. So we don't think this is a change in use. So I think the question is really even narrower. Is this a substantial extension of the use? And when we talk about whether this is a substantial extension of the use or not, I think it's clear what we're talking about here is the size of the structures. That's the only change here. It's 4 single-family structures, and it's going to be 4 single-family new structures. The only change is the size. And the question is, does that increase in size of these structures constitute a substantial extension of the use? In our view, it's clear that it does not under the relevant case law. Number one, size is a structural component. As I mentioned at the outset, structures and uses are regulated separately. Size can be and has been regulated by the bylaw. It's currently not. The provisions that restricted size were removed in favor of the setback requirements. So in the first instance, we think questions about size aren't properly addressed as questions of use. Those are structural and dimensional requirements. And I want to talk a little bit about the powers test that town council had highlighted in his letter, and I believe was highlighted in a memo I submitted on June 3rd as well, which I hope the board has. The powers test, which we agree is the correct test to apply, I think it's really helpful to look at what the court said in that case, and I've included some quotes on page 17 of this slide deck that are directly from the powers decision, because I think the language that the court uses is instructive. In powers, the court said, it is not different in kind, the use it's referring to. The use is not different in kind simply because it is bigger. It's not different in kind simply because it's bigger. That's all we have here. That is the only change. These new structures will be bigger. They are the same use. They are single-family residential structures. Under that, a non-conforming use of the same premises may not only be continued, but also increased in volume. You can increase a use in volume. That alone is not a substantial extension of use. We've cited, it's on the next page of the slide deck, but it's also in the memo, some cases applying the powers test. One in particular that I'll call the board's attention to is the Welch-Filipino case. And I agree with town council, most of these are in the commercial context. They are not in the residential context, and I'll speak to that in a moment. But the Welch-Filipino case, reconstruction of a nursing home. An existing nursing home was torn down, replaced with a new modern structure. The old nursing home was 40,000 square feet. The new one was 60,000 square feet. 20% increase in the number of beds, a significant expansion. What the appeals court said was that was permissible as of right. And the reason was that expansion of the nursing home and the replacement of the old structure with a new, larger structure that was not a substantial extension of the use. The use as a nursing home was not being substantially extended, certainly wasn't being changed. And I want to zero in on really, first I want to give some examples of what would be a substantial extension, because I think it's helpful to consider that in contrast to this. In the commercial context, perhaps you have a diner, it's a breakfast and lunch restaurant, and it's in a residential district, and they want to use it for a bar and nightclub at night. Conceivably, that's an extension of the use. You're using it into different hours of the day, you're using it for different purposes. Adding more structures could be an extension of the use. So here, for example, if you were tearing down 4 single-family homes and proposing 5 or 6 or 7, that arguably would be an extension of the use, perhaps a substantial extension. That's not what we're proposing here. The proposal here is 4 single-family structures for 4 single-family structures. I think what this boils down to is we're really talking about the size of the families that will live in the new structures, that there might be more occupants if we have larger structures or if we have more bedrooms. It's the same use, it's single family, it's not going to be multifamily use, but there could be more occupants. And I want to say 2 things about that. The first is that's largely speculative. We could have a family of 6, 7, 8 move into one of the existing homes right now. There's no prohibition on that. I don't think it's a sufficient basis to find a substantial extension of use simply by speculating that there could be more occupants in a larger home. But I think there's even a more significant reason why that should not be dispositive here, and in fact, can't be dispositive here. We're not talking about gravel pits or gas stations. We're talking about single-family homes, the use of which implicates fundamental constitutional rights. We're talking about people's families, who they choose to live with, and how many people they have in their family under one roof. We've already heard reference in one of these hearings to Mr. Larkin, who is going to occupy one of these. He's not just a developer, he's building his home on this property, and he's going to occupy this with his family of 7 people. He has 5 children. It's not a proper role for this board to try to impose limitations on the number of occupants in single-family homes under the guise of intensification of use or increased volume of use. To be clear, the town can regulate size, it can regulate height, it can regulate floor area ratio, and it's done those things. And this project satisfies all of those requirements. What's not a proper exercise of zoning authority is restricting the number of family members who can live under one roof. And that's the only thing I've heard suggested as a possible substantial extension of use here. Again, nothing else about this use is changing. The extension of use comes from the concern more people might live in these new houses than live in the current houses. That might be true. It might not be. Either way, it's not something that zoning can regulate. I also want to leave the board with one final thought to consider, because this board, I'm sure, has heard plenty of cases under the old bylaw. If we were here under the old bylaw with its restrictions on size, and these new houses complied with those size restrictions, in other words, if the applicant were here saying, I want to reconstruct 4 homes, I want to expand them all by 30%, frankly, we wouldn't be here at all. It would have been allowed as of right. And there have been other projects that have been before this board under that bylaw. There have been other projects with multiple structures on one lot. The use has never been an issue in those cases, as I understand it. There was one on Hart Pond on 7th Ave. The use was not an issue. They wanted to expand beyond the size limitations. We comply with all of the structural and dimensional requirements. So the issue of use, which is being raised here, which frankly hasn't been raised in other cases, it's really being used as a proxy for number of occupants. And we don't think that's an appropriate purpose of zoning regulation. We don't think that this board, under the guise of intensification of use or volume of use, can say this is a substantial extension of use, simply because more people might live in these homes. So we think it's not a substantial extension of use. And to be clear, what we're asking for is the building commissioner's rationale in the letter was purely structural, purely based on the footprint. Town council has given an opinion that he doesn't agree with that. We don't agree with that either. We're not asking you to send it back to the building commissioner to consider use. It's properly before the board. What we want the board to conclude is there has not been, or is that there's not proposed a change or substantial extension of use, and therefore this is permissible as of right under the bylaw. And I'm happy to answer any questions that the board has now or later during the hearing.
Does the board have any questions of Mr. McManus at this time?
Can I put in my 2 cents worth?
Absolutely, Joe.
Years and years ago, I used to be on the planning board, and one of the first items that came up was was 2 houses on one lot in North Chelmsford. And they belonged to the same gentleman, and he wanted to sell the houses. Well, someone told him he couldn't sell them. He had to split the lot into 2 lots to make each lot separate. So, planning board did that after some discussion. They found it to be an A&R. It was real simple, and it all got done. So I'm taking that to this case here, where we have 4 houses, and we want 4 new houses. I'm thinking that maybe a more correct way to do this would be to take each of those 4 houses that were there, separate them, and then expand them or remodel them or recondition them, whatever you want to do. But it seems to me that each lot should be taken separately. I don't know if that goes with logic or that goes with my logic. So that's all I wanted to say, that we shouldn't have torn down the houses. We should just make them each separate from the beginning.
And you know, I appreciate the commentary and understand the viewpoint. You know, I'm not sure, you know, how feasible subdividing this is under any circumstances at this time. And frankly, you know, I don't know that the applicant would be opposed to being able to subdivide. However, I have concerns about, you know, both from the standpoint that we believe the applicant can do this as of right, and from the standpoint of, you know, the effects on the neighborhood. Some of the changes that are being proposed, specifically the location of these, it's to pull them away from the lot lines, to bring them into greater compliance with current zoning bylaws. It can't be because of the size of this lot and the setbacks required. It can't meet the current requirements, but it can meet those historic requirements. So respectfully, I think that, you know, refurbishing the existing structures, renovating them, gutting them, what have you, even expanding them where they are, would potentially be more problematic from the standpoint of where they sit on this lot. And the issue of subdivision, again, I don't know whether it can be done, but our view is it's certainly not required to be done. I'm sure, you know, my clients can probably speak as to whether it's something they've looked into, but it's certainly not required for them to do in order to be able to reconstruct grandfathered structures as a matter of right, in our view.
Let me see his letter again. His letter, the building commissioner's letter.
And
I don't
as
have a
Michael
chance
Larkin
to-
mentions, it would most likely, I mean, I think it would create 4 non-conforming lots, number one, and then you would have setback issues with respect to each of those lots, because, you know, where the structures are, you wouldn't be able to position them to comply with all the setback requirements if you did that. So I think you know, from a practical standpoint, I think, you know, if there's going to be 4 structures on this lot, I think everyone would agree, it probably makes more sense for there to be 4 lots. I'm not sure it's possible. And there are 4 structures there on a single lot now. You know, I don't want to lose sight of that, you know, what we're talking about, the 4 buildings on one lot, everyone acknowledges is not ideal. That is the current state of affairs.
Are there any other further questions from the board? Seeing none, I'm going to see if someone in the audience would like to speak, either in favor or opposition to this application.
Thank you.
Your name, sir, and if you want to queue up in front of the podium, that would be awesome. Your name and address, sir.
My name's Bob Laporte. I live at 38 Parkerville Road in Chelmsford,
Thank you.
not far from this location. And I'm speaking in opposition to the development plan, and I'm in agreement with the town council's recommendation. I was going to speak about a couple things, but I just want to go over quickly the history of the property, because we've talked about use. And this is a property that has transitioned over time, but it was owned by the Byam family. And these camps were constructed from the 30s to the 50s and occupied as a family compound. They weren't individually owned, but they were just simply occupied, and their use was as a family compound. I think that use, whether it was legally or not, morphed into rental property, where these camps became rental properties, so that the use, I think, as of today, has always been, for the recent history, as rental properties and not for any other use as a single-family.
Was that a
House.
seasonal rental or a year-round rental?
I understand that it morphed into year-round. And you know, the other interesting thing about these houses are structures. I think there's no disagreement that the structures are owned by the applicant, but the land is not entirely owned by the applicant. So that one of these structures illegally encroaches on the abutting property. So the question in my mind is that, does that bring it to another level, this encroachment? And I
I
understand.
understand your concern, but again, we won't be ruling on that tonight, so it is an interesting matter to me as well, whether that is part of the calculation. The ruling will consist on whether by right they can build it. If they choose to, and there's issues as to whether the property is, and I understand your confusion, because the attorney stated they own the building, but the fact the building's not on their property is a
Right.
concern to me as well, but it's not something we're gonna address tonight.
So the change in use, you know, in looking at the assessor's records, you know, one of these houses is a one-bedroom house, camp. Two of them are 2 bedrooms, and there's one that's a 3-bedroom. So that currently on that site, there are 9 bedrooms. And I think what is being proposed is an increase to 12 or 15 bedrooms. You know, I guess that creates some legal arguments, but to me, that demonstrates that this is a substantial change in use of the property from what it currently exists to what is being proposed. So tonight, and I guess I'm not going to speak to this, but I do have concern over life safety conditions that will be created by this project. And I don't know if that's going to be consistent with what is before the board, but I think there are serious life safety issues that are being created by this new development. And if you would like, I could speak to what my concern is on that.
I honestly don't think that would apply to our decision tonight, so we're
Yeah.
gonna try to keep focused. I appreciate your concerns. I think that your concerns are founded. I'm not discounting them. I just don't think they're gonna apply to our decision, unless any of the board would like to hear the life
When
safety
you say
issues.
life safety, can you explain a
Yeah.
little bit about what you're
Sure.
talking about?
So this property was originally on a deed part of 2 lots.
Right.
There's the front lot on Parkerville Road, and there is this 1.42 acre parcel that's a subject for the application. So this lot that's subject to the application has no frontage. What it does have is access via a 10-foot wide driveway. That driveway is, the town has called that second lane. But second lane is not a roadway that is accepted by the town, maintained
Just
by
a
the town.
private way.
It's a private way. People have easements over this, and for emergency identification, they've called it second lane. So when you look at the number of bedrooms that are going to be created and the fact that this is a two-way, 10-foot wide driveway, that actually their rights extend from Parkerville up to this site, but it goes in 155 feet before you even reach the 1.42 acre lot. And part of that right-of-way, in fact, all of it, I think, is encumbered by a town of Chelmsford sewer easement. It has been, after they put in the sewer line, it got paved. But I've been before the Board of Appeals in the past, and I've been before the Planning Board on many times. And you always go to the fire department and ask them what they think about fire protection and how that gets handled. And to be truthful, on a 10-foot wide driveway that's used by many other people, boy, I don't know. I think, to me, that's
Getting
a,
equipment in and out. is
yeah.
getting-
I mean, we've had to, in our subdivisions, you got to make adequate location for trucks to turn around, and, we've gone to,
Okay. I just was curious about.
yeah,
what you
so
meant
that's
by-
where I was
Okay,
going on that.
okay.
But
Right.
if that's not the subject here, I just,
It's good
I think,
information, no doubt. We're not,
Right.
if we were trying to come to some negotiation on how this was gonna work, it would be much more applicable. We're
so
just
if I
trying
can
to-
ask this question, then, by approving it tonight, if the board were going to disregard the town councils, like life safety, does that ever come into, can they just go ahead and do it without concern?
So
of-
if we chose to disagree with the building inspector, they would be able to build it by right. If we choose to uphold the building inspector's decision, it would become a process of negotiation in a sense as to what they can do.
So the normal things like life safety would not,
It would be
it would
by
just be.
right. I mean, they would have the right to do it.
But, in fact, going from 9 bedrooms up to,
I'm not sure of the process, but I think that they would be required by the town to provide life safety features, such as a fire engine turnaround and things like that. I can't even say to that, honestly, because
Yeah.
there is no roadway.
there's no road, it's
there's no
just a,
frontage.
all they have is a 10-foot wide driveway.
Right. I
But if you
don't
build
know how
by
that would
right,
go.
Does the town still have to sign off? Like, does the fire still have to? They do,
There's a letter from the fire department in here.
Oh, that might be very helpful. I will read this into the record as well. This is from Fire Chief Gary Ryan, the Chelmsford Zoning Board of Appeals, proposed second lane development. Dear members of the board, this department has reviewed the proposed development for 2430 Second Lane and finds the following. The water supply appears to be adequate. Existing hydrants are within the required 500 feet from manual firefighting operations. A required pressure and water flow test will be performed proximate to the site, with all calculations submitted to this department. The existing hydrants shall be free from landscaping or vehicle obstructions. Access for firefighting apparatus is currently inadequate. The developer shall provide an approved fire department turnaround within the new development. Fire access roads and turnarounds shall be designed with a swept path analysis using the AASHTO BUS 45 turning template, and shall be designed by a registered engineer to withstand the weight of fire apparatus. Snow storage shall not obstruct nor impede the fire access turnaround, and the proponent shall install approved signage that designates an area for emergency use only. All fire protection features of all structures shall comply with applicable sections of the Massachusetts Building Code. The applicant shall apply to the Town of Chelmsford's E911 Committee for an address and unit numbering through its coordinator, Town Clerk Tricia Druez. This office would approve of this plan with these conditions, and I ask the board to make this letter part of their approval process. Respectfully submitted, Gary Ryan, Fire Chief. I have another letter here. I think I'll read that in just a bit. All right, I'll keep those together. The Center Water District has no comments. The Board of Health has no comments. So those are the letters from the town in the record.
So I guess I just reiterate quickly about the change of use. I think it is a change of use. I think these will end up being individually owned homes. And that is not the current use of the property. You know, it never was, and it was always owned by one individual, all the structures on the property.
Thank you.
Yep.
Hi, folks. My name's Robert Haig. My wife and I live at on 4th Lane at number 20. Thanks for the opportunity to make a couple of points and comments, observations. It's my understanding that 2nd Lane is owned as a residential district, which relates to the zoning bylaws, Chapter 195, Section 12, dealing with multiple principal structures, which interestingly starts, except in residential districts, which might imply that this is not permitted in residential districts, that principal structures may be erected on a lot pursuant to a special permit, which is issued by the planning board in accordance with 195-103. Two of the points that are in that chapter says that no principal building shall be located in relationship to another principal building on the same lot or an adjacent lot so as to cause the danger of fire. It's my understanding these homes will be 20 feet apart from each other. That's about the distance from me to you. I believe that to be a fire danger. All principal buildings in the lot shall be served by access ways suitable for fire, police, and emergency vehicles. As Robert was just mentioning, life safety comes into play. As I understand the plans, that 10-foot long extended driveway, which is not 2nd Lane, would terminate at a 3-car garage with his principal residence on the other side of that. In order for emergency personnel to get to the home, they would have to transit around the garage, which would be impeding their progress. The fire hydrant is also not anywhere on what would be 2nd Lane or that driveway. It's actually in front of the Lawler's house that the firefighters would have to hook up to the fire hydrant, cross the Lawler's property, over a retaining wall into a semi-swamp in order to fight a fire. So I think that Chapter 195 does deal with life safety issues, and they are addressed in that chapter as well. If I could also, non-conforming uses and structures have both been discussed here today. That's 195, Section 8. And it does say in Section B that non-conforming uses that the Board of Appeals or the Planning Board may, as is applicable, may award a special permit, which implies they may decline a special permit, for the non-conforming use in accordance with this section, only if it determines that such a change or an extension shall not be substantially more detrimental than the existing non-conforming use to the neighborhood. I believe it does. Further, there's 2 other clauses, be brief. Non-conforming structures, except, again, 1- and 2-family structures, the Board of Appeals or the Planning Board, as applicable, may award a special permit to reconstruct, extend, alter, or change. It sounds like that might mean or imply existing structures. Included the extension of an exterior wall along the same non-conforming line parallel to the required setback. But what it then goes on to say is that provided that the building inspector does not feel that it is substantially more detrimental to the existing non-conforming structure in the neighborhood. I believe it is. Lastly, on this one topic, the word by right has come up a little bit here, maybe implying that there is a by right authority to do things that are within the non-conforming area. Section E of 195.8 says that non-conforming single and 2-family residential structures may be reconstructed, extended, altered, or structurally changed upon a determination by the building inspector, and that such proposed reconstruction, extension, alteration, or change does not increase the non-conforming nature of that structure. I believe it might. This is an aside, if I could. There's a question about where 2nd Lane even fits into this. As we've mentioned, 2nd Lane, we know them as the lanes on this side of town. And the lanes are not a public street. And I might put before you that they're not even a private way. A private way would imply a single homeowner owns a long driveway. 2nd Lane, as it exists currently, is owned by easements to a number of homeowners, no one person owning that right-of-way or private way. That being said, there's been no test as to what would happen in a serious emergency. a water main break, a tree falls on someone's home, lands on a tree, on someone's car. And in that case, there's no question or answer as to what would be determined for fault or repair or costs. We collectively, voluntarily choose to put some money into a kitty to pay a contractor to pay our snow plowing every year, maybe perhaps fix a pothole or two. But that's the extent of it. We do so voluntarily. I think putting a condo association, as the plan calls for, provides a complexity that doesn't have an answer or a resolution should some sort of an emergency be required, like a water main break under the roadway. There'd be no way to determine who would pay what to make that fix, and I would ask you to consider that in your process. I think we all agree he has a right to build a nice home, perhaps build another home on that same lot, similar to the proposal that was before this committee about 1.5 years ago, and as is currently undergone or underway on 7th Lane, about the same size piece of property, 2 homes. But a condo association seems to abuse the intent of the original grandfather clause in Chapter 195 of the zoning bylaws to the detriment and the sanctity of the neighborhood as we live there now. Thank you.
Thank you. Are there any other further comments this evening?
Hey, guys. Benton Burgess, 52nd Lane. Thank you for letting us speak tonight. Before I start, I do have to commend the building inspector for, taking the action to deny the request. Gives us an opportunity to talk about this and figure out what we can all do. And I've heard about how you guys want to hear, would like to know about the conformity. You look at the paragraph that is of interest, that's giving us giving the folks the right to build. And in that paragraph, it says something about improving the conformity. Conformity is a tough thing to measure. How do you measure that? It's like nebulous. So you look at things in different ways. And I looked at the plans for the first time the other day, and I noticed that they're taking 3 houses. They're like 2,500 square foot, 2-story houses, and they're kind of shoving them into 1/2 an acre of land. Now, if someone were to come to you guys, someone else, and say, hey, I've got 1/2 an acre of land, I'd like to put 3 houses on there, I'm sure you guys would be like, you're out of your mind. So does putting those 3 houses in such a small area improve the conformity? I don't think so, not in my eyes. The other is the use. And Robert Hay brought up a good point where, we're going from a family camp. My family bought our house back in 1964. We would drive down the road and be a dirt road, and you would never know that there were actually 4 houses back there. Eventually you figure it out. But it was a neat little family camp. Parents had a house, kids had little 1-2 bedroom cabins. And, to me, how in the world does adding 3 big houses in a condo complex improve the conformity of the land? It just doesn't jive with me. The third measure of conformity is right here in this room. You look around the room, and there's a ton of people here who just don't think this is right. Would they be here if this was an improvement? You wouldn't see anybody here if this plan was a little more, if this was a true improvement. So I looked at that proposal, and it takes a non-conforming lot, and it makes the conformity worse. I don't see how this could make things better. That's just my opinion. So I agree with the town council, and I agree with the building inspector. I think, we should deny anything that tries to do so radical a change to our neighborhood. That's just how I feel. Thank you.
Thank you. Is there anyone else wishing to speak this evening? Is there anyone on Zoom who would like to speak this evening? Oh, good evening, I'm sorry.
Hi, I'm Pam Brevard, 49 First Lane. It's a little different than I expected tonight, but I would like to make a couple of points. And one has to do with Mr. Larkin's whole proposal rests on this 195.8E being applicable. We all agree this has been the big topic of conversation. But I'd like to introduce kind of a new way to think about it. And under 195.8E, it says structures may be reconstructed, extended, altered, or structurally changed. Which is really, if you look at extended, we're not saying they're proposing to extend it, any of these houses. I think we'd agree. They're not really looking to alter them, the houses that are there now. And they're not looking to really structurally change other than to raise them. They're going to take them all down. So that leaves reconstructing them. And that's what they propose to do. But what is meant by reconstructing a structure? To reconstruct is to rebuild, to restore a building of like kind to an earlier state with similar features of form, size, scale, materials, and level of detail. To do that is to reconstruct a house or a structure. And the whole purpose of reconstruction is to replicate in a general way the original design. That's reconstruction. In other words, get it back to normal. This is not what is proposed. What is proposed is a total replacement of the 4 structures that are there now. That's much more accurate description of what they are proposing. Replacement is an entirely different process and a different intent than reconstruction. Replacement is to put something brand new in the place of, and that can be from the ground up. In this case, the structures that are there will be gone. There will be no semblance of that. They don't have foundations. These new places will have new foundations, an entirely different form. If you look at the 571 square foot cottage and then look at the 2,500 square foot house that it's replacing, it has no semblance of the original structure in size, scale, or materials. So replacement can have few, if any, elements in common with the structure being replaced. So I ask you, what is going on here? Is it reconstruction or is it replacement? By these definitions and my research, it's clearly a replacement. And I contend that 195.8E does not mention replacing the structures, the existing structures. So that's one point I want to make for your consideration. Secondly, I concur with our building commissioner that the proposed subdivision, and that's what it is, it's a subdivision on Second Lane, vastly increases the nonconformity, and I'll address that, and skirts the planning board requirements for that kind of density in an environmentally sensitive zone. This is not a city lot. When I listened to Attorney McManus say, single-family home, we're replacing it with a, I think he did use, maybe not, I don't want to put words in his mouth. All right, so it's going to, it defies logic to me and common sense and the power of observation to say this is not a substantial change in use. We start with a beautifully forested, quiet, one owner, 4 rental properties, and we turn it into clear-cut, one huge house, which I have no problem with that. I think it'll be beautiful, and we'd welcome it to our community. and 3 identical homes in a row. So what's changed? I would contend that the whole relationship of the owners to the land is going to change. Because the owners of the 3 houses that are identical and 20 feet apart and organized as a condo association, what is their relationship to the land? Do they own it? Does the condo association own the land and therefore be really invested in its care and upkeep? No, there's no proposal to subdivide and have that condo association own the land that I know of. If there is, I stand corrected, but I don't think there's any proposal to subdivide. So what does that leave? That leaves maybe land lease? Does it leave some kind of easement right to it? In any case, the owners of those land do not own the land. This is a substantial change in the character of our neighborhood and community. We are very invested in our properties. We take great pride in them. And we take very good care of it. And there's a certain character that as you drive around Hart Pond, you will see. And the character is beautiful big pines and trees, and it's nestled. It's really a lakeside nestled community. And what is proposed is something you'd see more on a city street. And when you say, well, there's 4 single-family homes, and we're going to put 4 more single-family homes because that's just the current state of affairs. Well, we have an opportunity now to correct that current state of affairs by denying this proposal and looking for something, again, common sense. What fits into the neighborhood? What is healthy for this environmentally sensitive area? I think that's it.
Thank you.
And I would ask you to uphold the building commissioner's findings. Thank you.
Hi, thanks for.
Good evening.
Chris Bradley, 1 Lakeside Ave. Just a clarification for town council. Are you still against this proposal? That's for this gentleman, isn't it?
Mr. Haverty, yes. I don't think, he can answer for himself, of
That's
course.
what
I
I
don't
was
think he
gonna-
has an opinion.
Oh,
on
I thought
whether
I,
he's
I
for it
thought
or
I already
against
had
it.
an opinion where he said,
Well, I think it's by law, not a
Yeah.
personal opinion. Paul, you can speak.
So, Mr. Chairman, again, my position is that I believe the proposal to reconstruct the existing structure is consistent with the bylaw and does not require relief from the board. I think that the board needs to make a determination with regards to the extension of the pre-existing non-conforming use, following the guidance of the powers test as to whether or not what is proposed constitutes an extension of the pre-existing.
okay.
That ultimately is a determination for the board to make. It's not a determination for anyone other.
Okay. All right, I couldn't, and then I guess my only other question would be, when these folks bought this property, how many residents were on that property at the time? Do we know, Counselor, or? How many people lived there? One, two? 6. Okay, yeah. But so obviously now with 3, 4 homes, I mean, wouldn't there be and you spoke to this, Counselor, about added people, you can't hold that against us, but to me, that in itself is from 5 to 20 people. But that's just my opinion, but thank you.
Thank you.
Richard Byam. I reside at 51st Lane in Chelmsford, and I'm a butter to this development. Briefly, in the year 1999, I was going to build on a piece of property that my family has held in Chelmsford for a couple hundred years. And at one time, we had 4 or 5 structures there. Over the course of time, we tore some of them down. And at the point that I wanted to rebuild, I came to town hall and I said, I want to rebuild this cottage, this summer cottage, and turn it into a full year home. And I was told, in Chelmsford, you can only have one house on one piece of property. And I had 2 cottages, mine and the one that Pam Rivard is currently in, on this piece of property. And I had 10 acres of land, a lot more than what Mr. Larkin has. And at that point in time, it was explained to me that people used to build whatever they wanted to build and build as many houses as they wanted to, but that isn't in the town's interest, okay? And that the town had determined over the course of time, sure, my grandfather had built cottages and barns and different things on the property, but it is in everyone's interest that we have regulation. We can't allow people to build whatever they want, anywhere they want to build. And so the rules had been made pretty clear to me that I could only have one house on one building lot. And I had 2 cottages on 10 acres. So they told me I had to subdivide. Or the minute I tore one down, the minute you tore it down, you now have one cottage on one 10-acre piece of property and you can't build anything else. Now we're talking about a cottage that was built in 1901, another one was built in the 1950s. So I was going to lose the right to have a second house there unless I subdivided. So I subdivided property that's been in my family for hundreds of years that had been passed down to me, and no one had subdivided prior to me. And that was a tough thing to have to do, but I did it because that was the rules of the town. And now we have 2 pieces of property, one 7.5 acres, one 2.5 acres, and we have one house on each. That property that is at second lane, or almost on second lane, because I don't think they actually have frontage on it, has 4 small cottages. One was built in the 1930s, and I guess the most recent one was built in the 1950s. So this being 2020, that's somewhere between 70 and 90 years ago. So in order for this proposal to be accepted with the logic that they're attempting to proceed with, we would have to believe that when this bylaw was passed in 2020, it was the intent, and I think we should look at the intent. It was the intent of the people who passed that bylaw that every regulation that identifies what's an appropriate use of land in Chelmsford, this one house on 40,000 acres, etc., we're going to forget all that. And we're going to go back to what existed in 1950. We're going to go back to what existed in 1930. It would leave me wondering what that group could possibly been thinking to say, if you have something that was built in the 1930s and you knock it down, you can now play by the rules of 1930. And certainly, nobody in the town council, I believe, imagined that a 570 square foot cottage that was sitting mostly on someone else's property, on Pam Rivard's property, could be knocked down and turned into a 23 or 2,500 square foot condominium. And believe that was what the town council, that bylaw intended to allow people to do. It just, it defies all reason, in my opinion. And the idea of not changing the use, to take small cottages and turn them into condos, I don't know how anyone could say we're not changing the use. I keep hearing we're taking a single family home, okay, a 574 cottage, and turning it into a single family house. But is it a single family house if it doesn't have a lot? We're talking three identical condominiums built on a half acre of land that they don't own. I don't understand. I will never understand, if this is approved, how 1.4 acres, which under our current law is one building lot, could be used to build 4 homes, and how that is not a change. Putting in a condominium unit instead of tiny cottages. Of course, it's a substantial change in use, and I don't see the logic of it, and I cannot imagine that when that bylaw was passed, that was their intention to allow things like this to happen. Because I can't believe then I'm not sure what regulations is going to hold anybody back from doing just about whatever they want in town.
You know, we just can't, this isn't supposed to be time traveling where, well, if it was built in 1960s, we're gonna look at 1960s rules or 1920s or 1930s. It's 2020, there's a reason we have these things, these rules in place, and I would really hope that this board would enforce the regulations, look at the intent of this. That's it. Thank you very much.
Thank you.
Hello, Ron Wetmore, 45th Lane. I just want to build on what Mr. Byam was saying. I believe the intent of the bylaw was to allow people to deal with nonconformities for the houses where they are, where they're constructed, not skirt the planning board by creating a new subdivision in a condo association. And I'm also a little unclear if there's 3 houses with the condo association or 4. Do we have any clarification on that? I only ask because if there's 3,
To our decision.
well, again, if there's 3 houses, then they're subdividing the lot and leaving certain acreage with the new home on the water. So now they're subdividing the lot. So again, I'm not sure how this is all following, but
I
it
believe
seems
the
to
intent
be
would be
a
a land lease
bastardization
for
of the
condos.
intent of the bylaw.
Perhaps Mr. McManus can answer that, but again, I think we're getting a little off track of what our decision is tonight.
I understand. I'm just trying to get some clarification.
If he'd like to
I don't
explain
feel like
it
they're
to
here
you.
to subdivide the land, but it sounds like that actually is what they're doing. I'm just curious, because, again, the intent of the bylaw, in my opinion, was to help people who had something, reconstruct it, alter it, extend the use along a lot line where they normally wouldn't be allowed to. You're dealing with houses here that are straddling lot lines, don't meet the bylaw, don't even meet the setbacks. I don't think the intent was to be able to move homes wherever you want. That's a planning board decision. You're creating a new subdivision. So that's all I'd like to say. And again, it seems like an extension of the nonconformity. I think the building inspector's spot on. Again, it's in an environmentally sensitive area that no one's looking at all the other things that would get looked at with a subdivision as far as runoff, erosion control, all those things that get looked at in a subdivision. Fire department access. The fire department's pretty clear where they stand on this. So again, just wanted to reiterate, fortify Mr. Byam's arguments. This seems like a circumvention of the actual intent of the bylaw. Thank you.
Thank you.
Steve?
Seeing no other comments at this time, I'm going to ask the board if they have any questions of Mr. McManus or Mr. Haverty.
Steve's on. He's on Zoom.
Steve is on Zoom. Does he have any questions as well? I know he's there. I saw him.
Oh, you did? Okay. I wasn't sure.
I do not.
Okay. That, I'd ask for a motion to close the public hearing
I'll make a motion to close the public hearing.
and a second.
I thought Steve did.
I second.
Yes,
Steve seconds. All in
Yep.
favor?
Aye.
Aye.
Public meeting is closed. We can discuss any portion of this that you'd like. I would suggest we consider the powers test as it's referred to, and that is, I'll just reread it for, as set forth in the powers building inspector of Barnstable, 363 Mass, 648, 653, 1973, a test to determine whether non-conforming use will be substantially extended requires a 3-part determination consisting of 1, whether the present use reflects the nature and use prevailing when the zoning law bylaw took effect, 2, whether there is a difference in the quality or character as well as the degree of the present use, and 3, whether the current use is different in kind in its effect on the neighborhood. An affirmative answer on any of these 3 questions supports a determination that the non-conforming use is not protected. So I'll listen to any argument presented, but I think those are our basic focus on whether this is indeed by right or not. Any more stories, Charlie?
I can't think of any good ones. I have some good jokes, but I'm not telling them.
Big jokes tonight, no jokes tonight.
Could I make a motion, Mr. Chairman?
If there are no other questions from the board or discussion,
Could I, Mr. Chairman, I just want to briefly respond to one or two of the points that were made during the public session.
the public hearing is closed, yeah. I did ask.
Right, well, we're the applicant, we're not speaking as a member of the public here.
Mr. Haverty?
Closed is closed.
Mr. Chairman, once the hearing is closed, it's closed. The board can, if it chooses, take a vote to reopen the public hearing. But barring that, it can't take any more.
Would anyone like to make a motion to reopen the public hearing?
Should we, I'll make a motion to reopen the public hearing. So,
Do we have a second? So we do not take a vote, so the public hearing remains closed. Charlie, if you'd like to make a motion, if there's no other discussion among the board.
I'd like to make a motion, this is extreme case. Obviously, there's no other cases like this. We've heard from the building inspector, we've heard from our attorney, and lastly, we've heard from people, abutters, and we've heard many things. In lieu of all this, I'd like to make a motion to uphold the building inspector's letter of May 4th, 2021, stating that you cannot have multiple principal structures on one lot.
I'll second the motion.
Second by Aaron. All in favor?
Aye.
Steve?
Aye.
Unanimous? The building inspector. Thank you all for your time tonight. Thank you. I would ask for a motion to.
Oh, yeah.
Oh, you want minutes?
Yeah.
So we want to join? Okay.
I did read all the minutes too. I was like.
We're not going to adjourn just yet. We have some minutes to approve.
Yeah.
Chairman, I presume you're all set with me?
Maybe you could.
I think Paul was just asking.
Yeah. We have other business, yeah. I can talk. Do you want me to? Folks, excuse me, folks, if you wouldn't mind just clearing the room. We have other business for the board.
Down to a local tavern, wherever you see fit.
Pontoon boats on the pond.
There's a reason that's there.
That's why I know. Have you ever had to use that before, huh?
Well, I would have let them.
Quiet in the courtroom.
Vicious.
Well, Mr. Chairman, again, I presume you're all set with me then?
Yes, sir. We're going to go over our minutes and then adjourn. Thank you for your time.
All right, have a good night. Thank you.
I'm waving at Paul. Which camera am I waving at?
I don't know where I came. No, I came up.
I'm like waving here, and I'm like, he's probably just looking at like he's looking like the side of my head.
So we have some minutes. What do we have? The minutes of April 1st, 2021. The minutes of April 6th, 2021, and the minutes of June 3rd, 2021. Any corrections or additions?
Was that an email?
No, they were all on the agenda.
The link was
Oh.
on the agenda.
I put a little note saying,
Would you like to
"Please
review 'em?"
review." I said, please review, I'm behind.
Oh, I'm sure they're perfect.
There you
They're
go.
not very long. They didn't take me very long.
Motion to approve the minutes of April 1st, May 2nd, and June 3rd. That's not a motion, I'm
I'll
asking
make
for
a motion to approve the minutes from April 1st, 2021, May 6th, 2021, and June 3rd of 2021.
Have a second?
I cannot vote.
I'll second
I
the
missed
motion.
Second by Peter, all in favor?
Aye.
4-1, super majority.
Now you can.
Now I would ask for a motion to adjourn.
I'll make a motion to adjourn.
I'll second the motion.
Second by Peter, all in favor?
Aye.
Oh, yes, take that, good job.
She should be a lawyer.
She-
Is she a lawyer?
She's on the first
She
day.
might be, I don't know what her job is.
You're adjourned, correct?
Yes.